The next case for this morning is State versus Ira R. Leon. We'll give folks a little bit of time to get in and out here. Is it Miss Hightower-Henne? Henne, good morning.
Good morning. I'm Tracy Hightower-Henne, appearing on behalf of the appellant Ira Leon. I had the honor of serving on jury duty last week in Douglas County, and we struggled with the burden of proof in that case. So we found the defendant not guilty, and it made me think of this case. Had Ira Leon gone to a jury trial, I don't believe that a jury would have been able to find him guilty beyond a reasonable doubt of premeditated first-degree murder. So I have 2 points today I would like to discuss. First, I want to talk about the exculpatory issue and whether the DNA testing would produce exculpatory evidence. And second, I would like to talk about the felony murder issue. There are so many unanswered questions, of course, in this case, and I do believe that the DNA testing would help clear some of these inconsistencies. Now, we all know that the DNA Testing Act was intended for the specific purpose of helping to prove the innocence of the wrongfully convicted, but I don't believe we should forget the second purpose, and that's for wrongful sentences. And that's the case here at hand. Specifically where the Act says DNA may not conclusively establish guilt or innocence, but may have a significant probative value to the finder of fact. Now, the appellant understands that he holds a high burden of showing that the testing will produce the exculpatory evidence. And the DNA Testing Act simply defines that as evidence which is favorable to the person in custody and material to the issue of guilt. That is, it could clear a convicted defendant of a crime. In this case, the heart of the state's case is Stacey Fletcher's statements. I believe that DNA testing will prove that Fletcher is a liar. He was a self-interested co-defendant, and if DNA found on the victim is that to be of Fletcher's only, I would submit it would raise serious doubt regarding Fletcher's testimony, his statements.
Excuse me, you said if DNA found on the victim would be that of Fletcher?
Yes, Your Honor. There's some of the inventory in the state that the state had filed shows long brown hairs clutched in the victim's hands during the autopsy, and at the time of the murder, Stacey Fletcher had long brown hair.
Was that information known at the time of the plea?
I don't know if the defendant knew of that information. It was in evidence when he filed the motion for DNA testing. He was given that at that time.
Well, the autopsy had certainly been completed and was a part of the evidence, was it not?
Yes, it was.
I guess my question is, what information could DNA testing now produce that wasn't known at the time of the plea?
I would argue at the time of the plea, first of all, Mr. Leon was threatened with the death penalty. We have that issue. The plea was based on a premeditated first-degree murder theory, completely wrapped around Stacey Fletcher's testimony. He made up the story that it was Ira Leon that was the one in the back bludgeoning Miss Christensen to death. And he says that he has absolutely no contact with the victim, and I believe the DNA testing will show that he had substantial contact with the victim, and thus throwing out the basis for the plea.
Was he convicted of felony murder?
Stacey Fletcher?
Yeah, no.
Ira Leon?
Yeah.
He pled to a first-degree premeditated.
Does that plea make a difference?
For DNA testing purposes, it does not, pursuant to the Winslow case. This court has found that the plea, as a no-contest plea, still is available for asking for a motion for DNA testing.
Well, suppose it was DNA proved that Fletcher did the beating and murdered the victim. What difference does it make?
I know that's in your mind. Speaking of the felony murder, I'll move straight to that because I believe that's a hot issue for this this case. The state has brought up that idea that the testing would be pointless because Ira Leon would still be guilty of felony murder and thus still sentenced to life.
Was there a basis for the plea recited at the time of the plea?
As far as a basis in the mind of Ira Leon, I
guess what I mean is, did the state come forward and say, here's what the state could prove if we went forward to...
And then he immediately left. Well, the statement of Fletcher is that Ira Leon had came from the back after beating Miss Christensen to death. Well, Keith Davis had made no statement of blood on his white T-shirt. He made no statement of him coming from the back to the front. Therefore, I believe that inconsistency is a red flag to the factual basis.
Is there something in this record to the effect that if Fletcher were called to testify, he would say, Leon and only Leon beat the victim?
He might say that. With the entire record, I don't believe that would even be a consistent factual basis at this time.
It seems to me you have two problems. One, you can't show that the DNA wasn't available at the time, and secondly, you can't show that it would make any difference.
As far as the DNA not being available at the time, they did do some testing in preparation for trial.
Well, in fact, they did some testing. They could have done other testing, too, couldn't they?
Sure, if they would have gone to trial, I believe they would have done. I would argue at this point, this was in 1992, February 1992, the DNA testing, even in the statute, shows that a lot of the testing that we have today wasn't available prior to 1994, especially we're in a small town, North Platte. Their DNA testing is minimal to what we have today, and even that time in Omaha or Douglas County.
Okay, so the DNA testing shows that Fletcher did the killing. What difference does that make?
For the felony murders, that issue, I outlined this in my brief as well. This court has not yet had the chance to determine whether robbery and attempted robbery or lesser included offense is a felony murder. We have the most recent, the State versus Banks case, which cites the State versus Mason and State versus Borkland.
Robbery in which somebody is killed is not felony murder?
I'm sorry?
Robbery in which someone is killed is not felony murder?
I would argue in those cases, this court has specifically said in those cases there wasn't a rational basis to even go there, to even ask that question. And in this case, I would submit that there is a rational basis. Mr. Leon didn't even know that the killing had occurred until later when he was arrested. And I understand...
I'm sorry, Mr. Leon doesn't challenge that he was present during this
He doesn't challenge that. There is some question right now as to whether there was an intent to rob when they went into the store. I don't believe that's relevant now because of the fact of there's some case law that I think is open right now for this court to determine that rational basis. If this is a rational basis to determine that Mr. Leon could possibly have that instruction in a new trial that he could be convicted of the lesser included offense instead of the greater offense, the felony murder. And I would also...
What would be the lesser included offense?
The robbery or attempted robbery. And that's... At what point do those instructions go to the jury that the jury is able to determine that the defendant could be convicted of a lesser included offense rather than the greater included?
What rational basis would there be for that?
That's exactly...
the person died in the course of, the victim died in the course of a robbery, so what rational basis would there be for any lesser included offense?
That's my question, and I think we're at a point where that rational basis has not been defined as to what the rational basis means.
What rational basis could there be?
But you're not even there because you don't have a jury trial.
I agree. The rational basis, in my opinion, would be that Ira Leon may or may not have entered the barn store with the intent to rob, number one. Number two, I believe we do have the felony murder hanging over our heads, but in this case, he wasn't even aware of what was going on in that back room. So, thank you.
Thank you.